And this very and their attorney, I would, their person, but they would.
All I'll say is I wish they were here to decide the issue that did not take place. All right, ladies and gentlemen, let's sit down, please. Members of the press, audience, consultants, commissioners. We will present, or Mr. Flynn will. I'm very sorry to say that the Church of Scientology did not agree to participate any more than they did this morning. We would have liked to have questioned their witnesses as to the background of L. Ron Hubbard, whether or not he is a nuclear physicist, a medical doctor. Did he indeed serve in combat? Did he indeed heal his own war wounds and his own blindness? We would have liked to have asked many questions of the witnesses. I will leave Mr. Flynn. He has said is biased. I will let Mr. Flynn speak for himself. He is something personal in this case. I feel everyone in the city has a personal interest in this case. Many of the concerns he raised should have been raised by the state's attorney. Well, maybe he will now. The city's waited for 7 years for that to happen. This information should be helpful to the state's attorney for him to make a decision whether he should take any further action or enact any legislation. Concerning the legality of the trial, its hearings, even I'm getting like Mr. Johnson. Hearings, the question he raised has already been presented to the Federal District Court in Tampa, and they found that those questions did not prevail, and we were given the okay to proceed. Cross-examination. We in the City Commission also asked the same questions that you out there, you the people, have been asking for many, many years. So we feel that we did ask them the right questions. Each witness has informed us prior to Mr. Johnson's statement as to how they would be characterized, in some cases demeaned, by information used in their confessional. So robbery and blackmail and kidnapping are not the concerns of the commission. I feel they are the concerns of everybody in Clearwater. The tax issue was not directly discussed. I took special care not to discuss the tax issue. The issue of religion was discussed indirectly. I took special care not to discuss that. I just wish they had chosen to participate. As I said in the beginning of these hearings, the public has a right to know, and they still have that right to know today. As far as the legalities of this hearing, I would like to ask Mr. Buston, who is our city attorney, to give us his views on the issue.
Mayor, the only thing I want to say is that I think you've got to, as we said before, get back and look at this thing as to what it really is, and that is a legislative body looking into some factual data, trying to gather factual data to decide whether or not they can pass legislation. You cannot confuse the functioning of a legislative body with a trial. And you heard Mr. Johnson talk over and over again about trial and trial conditions and criminal trials. No way in the world can you equate the two together. And if you do, you end up with a bad product. No way can a legislative body function using the same rules that you would use in a courtroom scene. It's just not possible. And I have never watched a legislative body function in that way, either in Congress, in our state legislature, or anywhere else. He raised a lot of questions about our areas of concern. But I think what is quickly forgotten is that this is a city which has power co-equal literally to the state of Florida. Under the Constitution of the state of Florida, you are given what's called home rule power, equal to the state, except where the state says you may not act. Now, within that Constitution, it says you are to be concerned with the health, safety, and welfare of everyone in the city of Clearwater. And it seems to me that within the parameters of those broad grants of power under the Constitution, that conditions affecting the education, possible crimes, possible criminal conduct, abuse of information, all of this stuff goes to the health, safety, and welfare of the people that are residing or are in this city. It would be a weird legislative body or a weird local government that said expressed no interest in things like this that might be going on or were informed are going on in the city. And I think if you look around, you'll see other examples of where cities have looked at this when they become well, the easiest example is drugs. If you took the example that if you became aware of a drug problem in your city and the only person to turn to was your state attorney to handle it, you'd never solve any drug problem. There are a lot of things that need to be looked at, and those are the power areas in which you look at it. I think this is the whole thing that's been forgotten. It's not a question for this commission what Mr. Flynn is doing or not doing. The question you have to decide is from the factual information you've received in the last 4 days, whether that information supports the adoption of legislation. It doesn't matter. That's what you're judging. You're not judging Mr. Flynn. You're judging that factual information. Does it support some type or types of legislation? And I think that has been obscured totally in the whole process. In fact, I'm going to recommend that once the material is, there's so much it's so voluminous that the transcript of it be prepared. And then I'm going to, even in further assisting the commission in deciding this legislative question, contact a constitutional scholar I have in mind from another jurisdiction to even look at the transcript, helping this city commission make a decision based on the legislative aspects. And if the commission is so agreeable.
Thank you. Before we start with Mr. Flynn, and he has up to 2 hours of summation, which is the rules of procedure that we set forth the first day of these hearings, I'd like to give the commission a short chance, and I hope that they do not belabor it too much, but to discuss what has gone up to now or discuss the presentation of Mr. Johnson representing the Church of Scientology. So as is our custom, we're going to alternate, and I believe we'll start this time with Mr. Jim Calderbank.
Well, I was disappointed that the Church of Scientology did not enter into the record or participate in these hearings. Again, I'd reiterate that I always looked at them as an information and trial, not in a trial manner, but an information gathering. And I can't believe that the opinion or the advice to the Church of Scientology would be, do not take advantage of your 4 days to give your side of the story or give the facts, bring the records forward. There must be some reason for that, but that advice completely escapes me. As far as Mr. Flynn, in complex litigation, you need a specialist. And Mr. Flynn or that law office, at least when we were going through looking at not only city attorneys, and we did have Mr. Logan go over it before, but we needed someone that had the information already, the documents from Washington collated. We're not asking Mr. Flynn to make judgment. We're asking Mr. Flynn just to present us with facts and information, which I feel he did. I'm surprised Mr. Johnson, being a local attorney, would make the comments as far as our jurisdiction here in Clearwater and what the state attorney's office should and should not do. It's just like robbery, burglary, or even murder in this city. We don't have jurisdiction over that. The police investigate it. They can pick people up, but it's still up to the state attorney's office to try for that crime. So that was a moot point. And the comments about Mr. DeWolf and Mr. Meyer, Mr. Burfield very well and very vigorously questioned Mr. DeWolf about his recantation. And to the best of my knowledge, Mr. DeWolf told the commission and told the audience, the viewing audience, that he indeed did recant part of his testimony to the IRS. However, what Mr. Johnson did not comment on was which parts he recanted, which were the personal opinions and not the facts, and number two, the harassment to his family, to his children, and the threats that he had received. So yes, Mr. DeWolf recanted, but under Mr. Burfield's questioning, I think the situation of the recantation was better known to the commission, and I wish Mr. Johnson had stated that also for the audience. In addition, Mr. Meyer, who was an IRS quote-unquote consultant, he also stated that he was a consultant under our questioning, etc., etc. My only question would be how Mr. Johnson found out about the intimate personal details that he mentioned about Miss Van Schaik, who she came up of her own free will, how he found out about the psychological, or what he informed us was psychological and drug problems of not only Miss Van Schaik, but Mr. Ray. I can't understand where he would get such confidential information. And the last thing I have to say is I feel, and I think the commission would feel the same way, that with all the information that we have seen over the years, I think it would be malfeasant, or we would be shirking our responsibility not to look into these areas. That's our job, both legally and morally, as far as I'm concerned. And if some of the testimony was given that Scientology has changed, I really wish in the last 4 days that they had come up and shown it. And I just feel the record is a little less complete because of the advice not to participate. And other than that, there were some emotional comments put on the record, but the commission, I don't think will consider that when it gets down to the record. I think we'll be looking at the objective facts and see whether or not the record contains enough information to go forward, if there's enough factual evidence. Thank you.
Mr. Burfield, do you have any comments?
Yes, I do. If there has been one moment of humor to me out of this whole thing, there was a comment of counsel that we had not cross-examined the witnesses. My office received a call wherein I was not present but was chastised very vigorously, almost to the point of being harsh with the witnesses. And this particular woman said that I should never run for dog catcher in the city of Clearwater because of my partiality to the people of the Church of Scientology. So it's kind of unusual that 1 minute we're being criticized for not asking strict questions or cross questions, and then the next minute you're being chastised for it. I think we had a responsibility to the people of Clearwater, and that responsibility has come about from so many years of people asking questions, what's going on? I view these hearings not so much in light of all the testimony that was given, but what patterns were established? Were these patterns universal? Were they across the United States? Were they a corporate type of pattern? Sometimes it seemed like I was redundant in asking the question whether or not this could happen in Clearwater as well as in Las Vegas. And the testimony seemed to substantiate that. But as Mr. Calderbank pointed out here, we're concerned strictly with the facts. And those facts that come out of here, as counsel mentioned, we may not have any authority. But those facts should be related to the people that do have the proper authority. My biggest concern, and someone said it came out in my voice the other day, has been what Mr. Johnson chastised him for, and that was not the proper coverage of this thing by the news medium. I had been truly hopeful that the news medium would take every word verbatim and print it. If there was any concern about politics or people running for office, that they could have deleted the names of the commissioners and just put a down question and what the answer was, and let the people of Clearwater decide whether or not we have a problem. We have a lot of intelligent people here in Clearwater, and they wanted to know about it, and unless they've been able to watch Vision Cable, they have not gotten the full story out of this, or unless they sat down here. And I think if there was any injustice came out of it, there's where the injustice came.
Thank you. Mrs. Garvey, you have any comments?
There really isn't much that I need to say that hasn't already been said, except one thing that Mr. Johnson mentioned was the personal financial interest of this law firm that we have. And it's my understanding that Mr. Johnson is paid by the Church of Scientology, so I would assume that's personal financial interest also.
Mr. Patchett.
$250.
Thank you. Our two big concerns, City Commission, in these hearings was to listen for fraud and criminal conduct. Those are our basic areas. And I think we stuck to that very well. And anything else like taxes and religion, we asked it to be deleted from the record. I think a good job was done with that, in fact-finding. As Mr. Burfield stated, we were looking for situations of standard policy as a corporation, which you heard. I don't know how you can find out whether anything is going on, since you can't put a policeman on every corner and everybody watching everybody else. You know, how do you find out if illegal acts are going on? You find out when people step forward and complain. That's when you find out. And it's been stated before, that's our legal and our personal responsibility as commissioners to get on top of it. I believe that. The city has not made any determination of any testimony heard here today. And I was disturbed when Mr. Johnson stated that we are prosecuting, in a sense. We made no determination of the facts we found. We haven't even filtered them out yet. We just listened. I opposed Mr. Johnson stating certain things as he wanted to advise us before we went into the hearings. How would you know what any witness is going to say, and how you going to advise us before that person has a chance to testify?
It's a good point, Mr. Hatch.
How are you going to know what he's going to say? How are you going to advise us? Our municipal concerns, I'm for them, and I'm going to stick to the guns. Thank you.
Tony Shoemaker, the city manager, may have a few comments.
Mr. Mayor, members of the commission, I don't really have much to say. I think you said it very well. The thing that rather puzzles me is if the city commission and city officials are not supposed to be concerned about the health, safety, and welfare of its city, what are we doing? I mean, what's the purpose of us being here? Also, I'd like to inform you, as I think you know, that concerning criminal activities, the police department is going to be very active and very involved and very concerned about any types of criminal activities that occur within the city of Clearwater. And I don't really have anything else to say.
One of the small comment that they complained about Mr. Meister, whose daughter committed suicide 10 years ago for a dramatic time, and I made special mention of the fact that we're not here to determine whether how she died or what caused her death. It's just that that was not the issue here at hand. And to kind of narrow it all down to what we're doing here is that if a local church was running an illegal or a crooked or fixed bingo game in the city, we should investigate it. So why not investigate something on a much larger scale? So you bring it down to that. I think everyone can understand it in that context. Now, Mr. Flynn, you are our hired consultant. They have made a few personal attacks on you as to your motives, your financial arrangements made with the city, and the 27 lawsuits. You can comment on that, or you can ignore that and get on with your 2 hours of summation that was going to be given to us, frankly, 4 days from now, but it's going to be giving a lot much more sooner than that.
Mayor LaChair and members of the commission, Mr. Shoemaker and Mr. Buston, I would like to briefly respond to the attack against me because primarily it has some relevance, as much of the other evidence as I think my outline is going to show you, to all of everything that you heard for the past 4 days, or the 4 days during which we were in session. My outline is going to take some period of time, and we're going to have to go relatively slowly in order to cover a lot of the points that I'm going to bring up. But at the outset, let me simply say this with regard to a doctrine called the Fair Game Doctrine, which is Exhibit 1, and the attacker, which is Exhibit 3. I would submit that in some small measure, you have just seen a representative of the church employ those two doctrines against me. With regard to my financial interest versus my personal interest, or whatever motivating factors motivate Thomas Green to my left, Thomas Hoffman to my right, and Kevin Flynn further to my left, so far we have filed a number of lawsuits on behalf of people across the United States. We have worked very hard trying to obtain other counsel to assist us, and it's been a very difficult job. Litigation against the Church of Scientology involves litigation against many, many lawyers paid by the Church of Scientology. To date, other than what we have received from the city of Clearwater, and perhaps a very small amount from one client, of all the people that have approached us, we have received nothing. We anticipate litigation which could go for approximately 5 years. For the most part, I personally have expended all of my own funds to finance that litigation, probably in excess at this point of $300,000. I have spent a great deal of my time in the last 3 years. The cases are on a contingent fee basis, as has been reported in the press on numerous occasions. My clients have no money. There is simply no other way to prosecute those cases. Without a contingent fee arrangement, I could not motivate any other lawyer to prosecute those cases. The Church of Scientology has filed an affidavit recently in a case in Los Angeles in which they say they have paid their attorneys some $4 million to date to defend the cases that we have brought. In the connection with the Mary Sue Hubbard case, upon information and belief, I understand that some $3 to $6 million were paid to those counsel to defend those cases. So far, Mr. Hoffman, Mr. Green, Mr. Flynn, and Mr. Flynn have received virtually nothing except what we've received from the city, and we have withstood 3 years of incessant abuse, harassment, lawsuits, probably now numbering in the range of 9, of which probably 5 or 6 have been dismissed, unending bar complaints. My wife just received a telephone call late the other evening in which the individual said, is Michaal there? To which he said no, and she said, and then the caller said, thank you, dear, and hung up. Well, that is just a microcosmic view of the type of thing that we've withstood for 3 years. And whatever motivating factors are within all 4 of us and the other lawyers that are involved, they may be complex, but I can state for myself that the primary motivating factor is what this proceeding and all of those lawsuits will be about. And that is what the truth is. The nature of this proceeding, as the nature of any proceeding involved with the tripartite system that the United States enjoys of the executive, the congressional, and the judiciary, is to determine what facts are and then to make decisions based on the facts available. And all 3 branches of the government do that, and the state of Florida does that on a daily basis. This proceeding is to determine whether there is sufficient facts for this commission to proceed on questions that are vital to the city of Clearwater, not vital to Las Vegas or vital to Los Angeles, but vital to the city of Clearwater with regard to an international organization that has deposited itself under guise in your city and is conducting operations of the type that many witnesses have described, including Mr. Mayor. The international facet of the organization is of vital interest to the city because there are people internationally coming to your city paying millions of dollars based on policies, representations, publications, basically all of which have been issued by Mr. Hubbard and distributed by his organization across the United States, which, as in, for instance, in the situation of Mr. Hartwell, lured him into the organization. And when he was shown pictures of Clearwater and went out and looked in geographically to determine what Clearwater was, and he ended up on a desert and then almost was separated from his wife and then subjected to the fair game doctrine and has lived through a horror for the last 2 or 3 years. That is of some interest to the city, because your city was held out by this organization upon which Mr. Hartwell relied. And it so happens he ended up in a desert. And that's just one story out of thousands, perhaps. But it has some peripheral connection to the issues. Mr. Buston has basically covered the nature of these proceedings. I also did not have the opportunity to cross-examine if the Church of Scientology produced its witnesses. I have tried a number of complex cases, and I have utilized the tool of cross-examination in the past, including cases involving the Church of Scientology, and I forsook that opportunity so that not one, but 7 people from this city who are the elected representative of the people of this city, at least in 5 cases, would have the opportunity to ask those questions. If an ombudsman was selected to ask those questions, I'm sure that Mrs. Garvey, Mr. Hatchett, Mayor LaShare, Mr. Calderbank, and Mr. Burfield would have had many questions that they would have liked to have asked, but might not have had the opportunity to, given the time constraints. And it would have been, since this is an investigative proceeding, a severe, in my judgment at least, diminution of the opportunity of your electorate, of the people of the city, to find out the truth of what the organization is. Because its elected representatives would have been, for the most part, denied the opportunity to ask the questions that the people of the city of Clearwater elected them to ask. Similarly, if I had conducted a cross-examination in a non-judicial proceeding, or in an investigative proceeding, a legislative proceeding, which is non-judicial, you people also would have been denied the opportunity to ask a lot of questions that you may have asked. Now, Michael Flynn may have asked questions that Michael Flynn was interested in that he thought would have brought out the truth, but this is investigative. And the people of Clearwater, I'm sure, would have wanted their elected representatives to ask the questions that they elected them to ask, for which purpose they elected them. Now, the truth of a particular issue can come out in many ways. It can come out in the press. It can come out in a judicial proceeding, and it can come out in a legislative proceeding upon which ordinances can be enacted. The Church of Scientology was given an equal forum here. And yet, the Church of Scientology, at least I submit my personal judgment upon from reading the newspapers, has for many years had the opportunity to conduct its own public relations campaigns. And I would submit that if there has been adverse media attention to this organization in this city and elsewhere, it is because of the conduct of that organization that has led reporters to report what they've had. But this was an opportunity, as I said in my opening statement, for them to come forward and present evidence or facts which would rebut what has been published in the press, if the press is inaccurate, and give them the opportunity to present to you people and to the city of Clearwater, since it's on Vision Cable, what the nature of their organization is. Well, I submit that they chose not to participate because after the evidence that you've heard, there is no way that the Church of Scientology could put a witness on a witness stand and face 7 people and keep his basic integrity and look in the eyes of 7 different people, as my witnesses were required to do, and answer the questions that you people would have asked. If you put one exhibit on the transparency overhead projector, just one of many, many exhibits on criminal activities. Mr. Johnson said that there was no evidence of criminal activities. Well, we simply did not have the time to go through the hundreds of documents which were submitted to you people, which are just unending criminal operations in the city of Clearwater. There was nothing on the videotape except perhaps some reading of things concerning breaking and entering, larceny, smearing, framing, perjury, like TRL, which you may recall is how you teach a witness to lie, and things of that nature. I'm not sure he even saw the videotape, but there are many, many exhibits that are before the commission. But in any event, if any one of those witnesses appeared before you people, and just one exhibit, you could almost take any exhibit that's been introduced, take any exhibit concerning the confidentiality of auditing information, and you put that on the overhead projector, and you simply said to that witness, and I submit that this goes on every piece of evidence that's been introduced, you simply said to the witness, Mr. Witness, assuming that is true, we're not telling you that it is true, we're just telling you that we've heard some evidence, we've heard from some people where auditing information has been specifically used against people and has been used in a at least manipulative way. Perhaps extortious, perhaps blackmail, but at least manipulative and a little bit coercive. Would you have paid money, Mr. Witness, or would you have provided services, Mr. Witness, to the Church of Scientology if you had known for the past 15 years, if you want to make that assumption, the organization has been doing those things? Well, the witness obviously would have had to have said, no, I wouldn't have done it. Otherwise, he would be participating in the conspiracy. He would have had to have said no. As soon as one witness said no to one question of that type, you would have your fraud case proved by their witnesses. They could not produce witnesses. Instead, they chose to conduct what they've always conducted, a PR campaign to further deceive. They don't fight their battles in the courtroom. They don't fight their battles in an investigative proceeding. They fight their battles in the courtroom to delay the cases I personally submit to you on my judgment. We would go into court with any Scientology case tomorrow morning if we had the opportunity. But we won't get into some of the judicial problems. In any event, in this morning's newspaper, and I understand in yesterday's newspaper and in other news publications, the Church of Scientology chose to publish a full-page ad, at least in the Clearwater Sun, on what the Church of Scientology says is what its program and the nature of its organization is. And it says the Church of Scientology wishes to thank L. Ron Hubbard on the 32nd anniversary of his bestseller, etc., etc. Well, their current open house, which we'll get into, and their publication of something like this is their response not only to you people, but to its membership and worldwide. It's a PR campaign. It's not subjecting witnesses to 7 people to cross-examine. It's more of deception. And specifically, I refer to, in this particular advertisement, the following. Walter Winchell first hailed Dianetics prior to its publication. Well, since it's prior to its publication, which was sometime in 1950, I would assume that it was sometime prior to 1950, at least a day or so before the publication. And I don't know how much Walter Winchell knew about Dianetics at the time, but perhaps he also was deceived. But anyway, they published the following quote. There is something new coming up in April called Dianetics. A new science which works with the invariability of physical science in the field of the human mind. Well, one of the last exhibits, perhaps the last, I put before the commission was the case of article or device, in which the article or device case said, in essence, in any publication in which Dianetics, auditing, Scientology, etc., is referred to in 11-point leaded type, you have to put in that all of those things are not capable of curing any disease, preventing any disease, etc., and I won't dig out the exhibit at that time, but that's basically what it says. An 11-point leaded type is large type.
Is that disclaimer on there?
There is no disclaimer in this publication. Mr. Johnson mentioned the Christopherson case in Oregon, and he said that one of my cases. I have nothing to do with the Christopherson case. That case started before I ever heard of the Church of Scientology. And absolutely nothing to do, and if I was sworn in by Mrs. Williams, I would so state under oath. But I have nothing to do with it. The Christopherson case has been reversed and remanded for a new trial based on the article or device case, which Mr. Johnson did not tell you. He also didn't tell you that the article or device case was first tried before a jury, and the Scientologists lost. And I give their lawyers and their ability to hire lawyers, I give that whole program incredible credit, because they get very, very talented lawyers that they pay large sums of money to, who do a tremendous job. They succeeded in getting that first article or device case reversed and remanded for a new trial. And there was a second trial, and the Scientologists lost again. And it went back up to the Court of Appeals for the District of Columbia for the second time. And they lost again, and the warning that was one of the last exhibits that the judgment, including the warning, which was one of the last exhibits that I filed before in these proceedings, was the end result of that case. So that case, through the talents of their counsel, was also reversed and remanded and retried. And Nathan Dodell, the individual for the government who participated in those proceedings, could give you what the 5 years of horror he lived through to litigate those two cases. One case, but two trials. And perhaps someone in this commission should contact Nathan Dodell in Washington, D.C., and ask him what he went through to litigate article or device. The article or device case is of obvious significance to this commission and to the state of Florida. And as you have seen in something published this morning, there was no such disclaimer. I suggest to you the deception continued right up to the publication of this Clearwater Sun edition this morning, and right up to the failure of the Church of Scientology to present any person before you under oath who could answer your questions. That is also a form of deception in conjunction with this type of a publication. One other point that was brought up was the fact that somehow Mr. Johnson had information concerning Mr. Ray and Miss Van Schaik's brother-in-law, and he made reference in his remarks to the psychiatric background of those people, and he suggested to you that Miss Van Schaik's brother-in-law apparently, he says, had attempted suicide. I would suggest to you that that statement, although Mr. Johnson was not under oath, has at least inferentially proved our case. Where did Mr. Johnson get that information? Where did he get that information? Where did he get the information about Miss Meister's background? He apparently has just been hired. He filed a lawsuit 1 week before these proceedings began, although the lawsuit could have been filed when the report was presented. And he told the court that he didn't have he told the press that he didn't have the opportunity to present a defense because he had just come into the case 1 week beforehand. Well, if that's true, I admire Mr. Johnson's investigative talents because I've been investigating for the Church of Scientology for 3 years at a great deal of cost, and I don't have the ability to come up with that kind of information that quickly when a witness is on the witness stand just a few days before and he uncovers the information quickly enough to present it before you at 9 o'clock on a Monday morning. And also included in there would be Miss Meister's background, Mr. Ray's background, and I believe there was reference to one other. But in any event, I would seriously scrutinize that type of statement as to where that information came from. Let's assume that there was a psychiatric background. Well, if there was a psychiatric background, and any of those individuals, including Susan Meister, was subjected to any of this processing in which a disclaimer was not given, your case would be further proved, not disproved. If, in fact, that person was ill, and they were subjected to R245 or any other such things, and that had any degree of inducement or motivation in the suicide of that individual, that would be matter for your serious scrutiny. Because then you would also be getting into the unlicensed practice of medicine if the person was ill. There are many such questions that have to be answered in detail about the nature of this organization. And when we present our final analysis of all of the facts that are specific, non-hearsay facts on this record, and I submit to you, those facts, as we will list them, will be overwhelming in my personal professional judgment. You may have heard a lot of hearsay, and you heard 4 days, and you may have thought that there was in some instances, a lack of specificity. In some instances, the testimony was too vague. I submit, and I think perhaps even some reporters alluded to that fact, I submit that to make that judgment, you have to know the issues, both the legal issues and the factual issues, in some detail and study them for perhaps a couple of years to determine whether or not the specificity is there. Someone like Mr. Walters getting on the witness stand and starting his testimony, you could hear him, and your minds could select facts, as the reporter's mind could do, that he listened to. But you may miss very pertinent facts, which 4 days later, after the city and you people got a little education, because it was your first opportunity, because you people had the courage to do this. It was your first opportunity to get educated. When you go back and look at some of his testimony, in the light of what you learned 4 days later, you may see a lot more specificity than you thought. And just one little for instance comes to mind. Mr. Werner testified that she observed, and you can correct me if I'm wrong, and the videotape will correct me if I'm wrong, and the written record will correct me if I'm wrong, she observed a 9-year-old child, sick, who couldn't lift his head. And she observed the medical officer pull out a book. It was a medical textbook to see, well, what's wrong with this child? And then there was some discussion about whether his ethics were in and out, if I recall correctly. And the medical officer treated the child from this medical officer, not a medical doctor, prescribed treatment for a child who couldn't even lift his head. Well, to me, that witness, observing that fact, is a pretty specific piece of evidence. Small piece, but specific. I believe she also testified that she saw children carrying files throughout the day around the organization in the age of 10 to 13. And the record could correct me if I'm wrong. It's a small little piece. But the rapidity of all of the speed with which all of these witnesses testified in the 4 days with which they tried to get out pieces of information, I think will show that there are many such hundreds of little pieces, such as these children throughout the day carrying around files, working for the organization when they should be studying. The next day in the newspaper, there was a statement, I believe, that said something to the effect there was no evidence. Well, that's just one little piece of evidence. And I'm not saying that the reporter even necessarily was, on those subjects, there was no evidence, I believe was the statement made. I'm not suggesting that that reporter was unfair. I'm simply suggesting that he heard what he heard at the level of education that he was on about this subject, which maybe if he heard it after studying it for 2 years, he would have been listening a little more attentively. And the mind tends to select, particularly certain parts of our society, namely the media. And I'm not attacking the media, I'm just saying it's the nature of things. In the nature of things, the more educated you are about a subject, the more you know about it, the more you will hear the details, and the more you'll key in on the details and the significance of them. The less you know about the subject, the more you'll tend to see the high-profile items and report those. And I suggest to you that some of the most significant testimony that's been heard in the last few days was something that has never even been printed or mentioned. Some of the most significant testimony. Mr. Mayer was obviously high in the organization, and he knew a lot about the organization, and he was a particularly appealing witness for that reason because he knew it from the top, and he gave you a lot of facts which he knew. But some of the most significant evidence came out of kids like Kelly and Ray, and very, very small items, which when all put together should give you a picture of what this organization is and what it has done, what its policies are, and how you can predict how those policies will be implemented in this city in the future that you have to deal with. Some of the most significant evidence came from individuals in the beginning of the hearings, which was put in a better light or a proper perspective as the hearings progressed. But the facts, as we will go through, in a very limited degree today, and I stress, extremely limited degree, because we don't have the tapes, we don't have the audio tapes or the videotapes, we don't have a transcript, and just from our own notes, we put together what both we expected them to say and what they did say. Witnesses in a judicial proceeding can be led by a lawyer on direct examination. If this was a trial, I could have got up and led any one of those witnesses through the examination. It's called a direct examination. I could have asked each witness in very specific areas, as Mr. Buston and Mr. Burfield, being attorneys particularly now, I could have led them through questions on very specific areas, and I would have keyed in on the issues that I wanted to key in on. And I submit that would have been an enormous advantage for me in the presentation of this case. I did what most lawyers will never tell you, or will tell you not to allow your witness to do. To just get up there and tell it like it is. And subject himself to 7 people, and whatever comes out, comes out. Now, in a direct examination, I could have shaped the testimony a lot more. I specifically chose to just allow the witness to get up there, and if the witness lied, then that's the witness's problem. The witnesses were told not to lie. If the witness made a mistake, then that's the witness's problem. If the witnesses had discrepancies or inconsistencies, and you people brought out those discrepancies or inconsistencies, then they're on the face of the record. But as I suggested to each one of you before these hearings began, all witnesses, every witness, will have mistakes and discrepancies of some nature in his testimony. It's the nature of things. The mind is simply not perfect. You will always have those items. Your job is to, you're not really triers of fact here. You're basically here to determine whether there is enough facts to determine whether you should do something about some legislation which may be needed in this city. You're not specifically finding facts, although in this case we will suggest that you do, But the law does not require you to do that. So in this particular case, to be more protective of Scientologist interests, we will do that, but it's not required. When you sift out that evidence and based on your scrutinization of the individual who appeared before you, as human beings, using your common sense, you draw many inferences, receive many facts, determine whether you think the person may be shading that, lying about that, telling the truth there, more open here, less open here. You see all those little nuances. And the fact that there are 7 of you who are seeing all those little nuances is even more protective of your city than as if one person, a judge, saw all those little nuances. So in sum, on the basic issue of the nature of the proceedings, I would submit that the Scientologists had a fair shot. They chose, for the reasons I've suggested, not to participate. And you people scrutinized the witnesses that I produced. You have the record. You'll find the inconsistencies and the discrepancies, and you'll come to your own conclusions. I would point out one further fact on one of Mr. Johnson's statements. In most jurisdictions, as Mr. Buston and Mr. Burfield know, there is an exclusionary rule of evidence. And I can't speak for Florida because I'm not precisely familiar on this specific item of Florida evidentiary law. But in most jurisdictions, there is a psychiatric exclusion of psychiatric records in a judicial proceeding. If Lavinda Van Schaik's brother-in-law, or Susan Meister, had a psychiatric condition, in a judicial proceeding in most jurisdictions, that would never have come into evidence. And yet he stood before you and raised that issue. And I bring that up because that is a very important point on a cross-section of everything that a cross-section of issues on everything that you've heard. And that's the fact in all the issues relating to the confidentiality of auditing. With regard to this signed confession of Mr. Ray of criminal activity and drug usage, well, I wonder where they got the signed confession. One of the issues that has been presented is the fact that before people leave, they have to sign their life away. They sign releases, non-disclosure, waivers, all types of documents like that. They sign documents which they don't know the contents of when they come into the organization, and they sign documents such as Tanya Burden signed on December 17th, 1977, which are in evidence after she was taken to Las Vegas, from Las Vegas to Los Angeles, locked in a room, put on the e-meter, and signed documents. To this day, she's not even sure what they are and how many they are, which we are trying to procure. Some of those types of documents have been put into evidence, and I won't go over them all now because we simply don't have the time, but in my final analysis, I will. But I personally know from my 3 years of investigation, and I suggest to you that that evidence that I've presented will show you, that anyone who leaves the organization signs so many documents releasing and waiving everything, saying that he's the one responsible, he's the one who committed crimes. It's a regular, routine, everyday occurrence in that organization when anyone tries to leave. And it's a very important interest before this commission. Because when David Ray tried to leave, I know, and he probably doesn't even realize it, I know from the policy of the organization, which we have put into evidence, that he signed things and said he did things, which as an 18-year-old child, he probably to this day doesn't know the contents of. And I would submit to you that a logical inference would be that David A. Ray would not sign such a document that Mr. Johnson says he's got in any other proceeding. He'd only signed it for this church. That in itself is a legal issue of great significance to this commission. Because what that individual did, according to Mr. Johnson, is sign a statement that he was involved in drug use and a theft. And he signed it for the church in order to get out of the church. And the church brought it in here before you and told you about it. Perhaps if the church, as Mr. Johnson suggests, that the Pinellas County State's Attorney would be the appropriate individual to hold hearings or convene grand juries or to do whatever within his jurisdiction is to do, he should have brought the document to him. And one other point, I believe Mr. Mayor told you he was an IRS consultant. And I believe Mr. Johnson said that that fact could have been brought out in cross-examination. Now what we will do is I'm not sure what time we started, so you can just let me know how much time we have left. We will get into, just very peripherally, and I have to, again, strenuously...
You have about an hour and a half, sir.
Thank you, Mayor. I have to very much emphasize that this recitation of some of the evidence that we're going to go over and perhaps some of the legal conclusions that can be drawn therefrom is intended to be a very peripheral framework and outline of what the interests of the city are, what the city should inquire into in connection with the evidence, and what ordinances can result from the evidence. It's only intended to give you some idea of the areas that you could be looking into, and to collate and present to you some of the evidence as it correlates to each other, to different pieces of evidence.
Will you need the overhead?
It basically will depend on the time. We may need it. If I have enough time, then I'll start putting things on. I've tried to conduct our portion as expeditiously as we could. I mean, there are hundreds of documents that have been put in evidence, any one of which, for instance, the document on drills and how to commit larceny and burglaries and breaking and entering, we could spend, it's a multi-page document, we could spend 4 days on that document. Now, in the final 2 hours that we've been allocated, the 2 hours is both argument and the presentation of further evidence under the rules. And in fact, if the Scientologists had chosen to present further evidence, then I would have chosen to present further evidence also. In fact, I have a witness who I held for that purpose, which I'm not going to take the time to go into, because I would suggest to you that there are, in our investigative efforts in the last 3 years, there are another 50 or 100 such witnesses, if they had the courage to come forward, would come before you and testify also. But I am going to put in a few more pieces of evidence. Now, one of the items is a book called What is Scientology? And we're going to offer this into evidence, and we'll do it when I conclude my presentation, for a number of different reasons pertaining to the confidentiality of auditing, the disclaimer that is required under article or device, and representations that are made to members of the Church of Scientology. There is an extensive biography in here of Mr. Hubbard. Now, it's pertinent because this particular volume is one of their largest collections of information about what the organization is and how it presents itself. And already in evidence, you have some biographies about Mr. Hubbard, which is going to be one of the first areas I'm going to address. You already have some evidence on that subject in this is going to give you a little more. I would submit that the biographical outline of Mr. Hubbard in this document, as it has been changed through the years to conform to specific facts in prior biographies, which are still published, but aren't published as much or disseminated perhaps as broadly as this one, will show you what the organization has done as they have learned about some of the representations about Mr. Hubbard's background. In the last 30 years, I would suggest to you that the Guardian's Office is a particularly skillful intelligence gathering operation. And I would suggest to you that they have learned some facts which perhaps at another commission hearing or at another date could be gone into in considerable detail. But I would suggest to you that the organization itself over 30 years learned something about Mr. Hubbard. And I would suggest that the few biographies that we've put into evidence, together with this biography, which we saved, will show you how skillfully they have rewritten their latest biography. And yet all of the suggestion and all of the inferences that are made in the facts that are set forth, the way the sentences are put together, will show you that they are suggesting the same thing that they said in biographies years ago, which are already in evidence, namely that he was a graduate of George Washington University, Princeton University, 4-year combat veteran who healed his war wounds, that he was crippled and blinded from the war, and he healed those wounds through the power of Dianetics and auditing, that he's a nuclear physicist, that he has years of research and case studies in his preparation of Dianetics, and that all of those facts are to be relied on. I would suggest to you that the early biographies specifically make those statements. The later biographies put the sentences together in such a way as to suggest those statements and those inferences. And as the witnesses testified on briefing courses, of which unfortunately we don't have the videotapes that are shown to people in briefing courses, but a number of witnesses testified about, including Mr. Walters. On briefing courses, they're told those things, but the public doesn't get the briefing courses. They're told specifically, and it is common knowledge among Scientologists. As Mr. McKee said, he gave him some poetic license because he's got an engineering background and he's a fairly mature, sophisticated man. But you take an 18-year-old kid who's over at the Fort Harrison working 17 to 18 hours a day for $9.60 a week, and the inferences that he may draw, as opposed to those that Mr. McKee may draw, are significantly different, and that's an important fact for this commission to consider. In addition to that, just the very pattern of change can suggest to you deception, and in courtrooms across this country, it's done every day in a judicial proceeding. Among the things that this book says right at the beginning is what is called Standing Order Number 1. Laurie Taverna testified on the SO1 line. Well, at the time, the SO1 line, I'm sure, went over everyone's head. The SO1 line, as some of the documents will show, is Standing Order Number 1. Standing Order Number 1 of the Church of Scientology is that everything that is written to Ron is received by Ron. And it is designed and induced to motivate that individual to believe that L. Ron Hubbard, the scientist, nuclear physicist, the man of great training and skill who has developed this technology, is always there, will always help, will always correct, and will see to it that everything he's represented is true. And one of the very first pages in the book is Standing Order Number 1. You can always write to Ron. In every org you go in, including the Fort Harrison, you'll find that right in the lobby probably. I've never been in the Fort Harrison, but I know it's in every building. All mail addressed to me shall be received by me. I am always willing to help. By my own creed, a being is only as valuable as he can serve others. Any message addressed to me and sent to the address of the nearest Scientology church listed in this book will be forwarded to me directly. Well, on the very first page, I would submit to you that that's a deception. I would submit to you that L. Ron Hubbard doesn't know Tanya Burden, well, did not know that when Tanya Burden was complaining, as her affidavit states, which is an exhibit in this case, of the conditions in the cadet org in Los Angeles in 1973 when the milk was laden with maggots. And she wrote as a 13-year-old child, as her affidavit says, on SO1, I submit to you that Ron didn't do anything about it, as her affidavit shows, which is in evidence. In connection with the creed to which Mr. Hubbard referred, Mr. Hoffman has just indicated to me, and this is not on file in the proceedings, but we will file it to you. In one case, they filed an affidavit saying that SO1 is not quite accurate. The mail doesn't go to Ron. And we will file that to you and mark it as an exhibit. Some of the things that Mr. Hubbard refers to in his creed are the following: that all men have inalienable rights to think freely, to talk freely, to write freely their own opinions, and to counter or utter or write upon the opinions of others. Well, there's many things in this creed, and I'm not going to go through them all because I don't have the time, but they're all of a similar type. But on just that one, I would submit to you that you heard from Paulette Cooper on her ability to write freely. With regard to Mr. Hubbard's background, we've heard a lot of evidence. I think virtually every witness testified that to some degree or another they relied on it, or that they would not have joined if they knew that it had been falsified. Some gave testimony of more specific reliance than others. Some people, like Mr. McKee said, he gave him poetic license. Well, I wonder, that was for Mr. McKee, that was 24 years ago when he was a lot younger, and the memory tends to lapse a little bit, but we'll take his testimony on the face. And, maybe he developed poetic license over the years. Maybe he relied on it a little more strongly when he was younger than he did now. And I would suggest to you that that is an area in which you scrutinize every witness. Just because they're the witness presented by the consultant doesn't mean you can't scrutinize as to whether or not his memory 24 years ago would have been a little bit better. Whether it supports what the consultant is alleging, or whether what the Scientologists have failed to allege and come before you and prove. From both sides of the fence, as I think I tried to instruct you at the outset, you can look at this evidence impartially from many different directions, not just as to whether it proves that Scientologists have done a certain thing. But I believe most witnesses to Werner, Kelly, Pace, and Ray, Van Schaik, Peterson, Mayer, and Dardano either testified that they specifically relied on it, that they generally relied on it, or that they would not have done it if they'd known that it was false. Now, his credentials about being a war hero, well, let's take being a war hero. Now, the chronology that we put into evidence of Mr. Hubbard's naval background shows you his duty stations. It shows you where he was every time he changed duty throughout the war. Now, we didn't have the time to go list them one by one and every 3 months change, but if you take the time and you read through them, you'll see where Mr. Hubbard was. You'll see that he was not a commander of corvettes in the South Pacific, as he says in one statement. You'll see that he was not battling submarines in the North Atlantic, as he says in another statement. Just that simple little document will show you where he was during the time he was in the Navy. With regard to his wounds, we're going to put into evidence a Veterans Administration physical examination of Mr. Hubbard that will give you his physical history and what he suffered from while he was in World War II. He didn't have any combat wounds. He had a duodenal ulcer primarily, for which he was treated at the Oak Knoll Military Hospital, at least on the face of the records, for 3 months at the end of the war. Shortly after, he was discharged from duty 24 hours after the Coke bottle was found on board the USS Algol, which a few days later, as I suggested to you, and I would further say that at this point we have not put into evidence anything as to where the Algol went. I'm not sure it's even important, but in any event, what is important is that he was discharged from duty 24 hours later after he found the Coke bottle. And then shortly thereafter, he ended up as an inpatient for 3 months in a hospital. And then shortly thereafter, actually it would be a couple of years thereafter, which in itself is of significance, he wrote a letter to the Veterans Administration saying he was mentally ill. There are all types of issues as to how long he was mentally ill, how mentally ill he was, and how much that affected his judgment not only during that period of time, but subsequently when he was writing Dianetics and when he did his 30 years of case studies. All of those pieces of evidence have many different inferences that could be argued about. Inferences can be drawn. Legal inferences could be drawn and presented to a trier of fact in a judicial proceeding. As an investigative body, it's not even necessary, but it gives you some indication, some specific facts upon which you can draw inferences and derive some knowledge about his background. And I'm not suggesting that Mr. Hubbard's background is the most important issue in this proceeding. It's one of the more important issues because everything stems from him. But I would suggest to you that there are more important issues. But the evidence that we've introduced, together with DeWolf's testimony, well, DeWolf recanted at some point under duress, which he says under duress. Well, legally under duress, it wouldn't even be a recantation if, in fact, it was under duress, which is a separate issue in itself. But even if you assumed that it wasn't under duress and it was a retraction, then you would have to look into what he retracted. Well, we haven't even bothered going into that peripheral issue because it's so peripheral in light of everything else. But I would say, I've read the retraction, and I will say nothing more about it. I hope the Church of Scientology had walked into and presented evidence on the retraction. And we left the issue open so they could present the retraction to you, which they chose not to do, so you could read the retraction and see what it is, as Mr. Calderbank very incisively pointed out, what the retraction was. And we'll leave that issue there. But I suggest to the church right now, if they're listening, bring the retraction over.
Would you enter that retraction into evidence?
If you people would like to see it, we'll put in the retraction.
Since it's
been raised as an issue. But I would suggest to you, it's in the light of everything else, it's relatively peripheral. But we'll bring the retraction in. Even if he had retracted, there are issues as to, well, as would in any judicial proceeding, you can believe all of his evidence or none of his evidence. You can believe part of it, accept part, discard part. The issue for you with regard to Mr. DeWolf, after looking to him, listening to him, where he openly told you that he had made a retraction under oath, is to determine whether what he said you thought was basically true. If he had mistakes in dates, he had mistakes in dates. If he had mistakes in subject matter, he had mistakes in subject matter. If he didn't, he didn't. Weighing it against everything else, it's for you to correlate all those things and to determine whether basically the thrust of his testimony that his father was a fake was true or false in conjunction with all of the other evidence. And as you may recall, he said 99% of it was false. And as I previously suggested, there are a number of exhibits and evidence which corroborate, very specifically, corroborate his testimony. In some cases it's of importance, in other cases it's of less importance. And for the record, I would specifically refer to Exhibit 20, Exhibit 21, Exhibit 22, in Exhibit 23. One other point. The reason that, as I suggested in my opening, Mr. Hubbard's background is of significance is because Scientology, as you have seen from the mouths of the witnesses and from some of the publications, is not presented to people here in Clearwater as, I would suggest to you, a belief in a mystical religious subject. And I'm not going to get into religion here. I would just, picking up this particular news coverage this morning of this publication, it's presented with the invariability of physical science. That's how it's presented. And Mr. Hubbard's background is designed to be promoted in such a way as a nuclear physicist, and as I suggested to you before, inferentially, a medical doctor. At least inferentially, but definitely a nuclear physicist. As this book, What is Scientology, if I took the time to read it, would show to you, the presentation is one of science. That these are specific items that have been researched, evaluated, correlated, and through the scientific method demonstrated to be scientifically accurate, upon which scientific representations and guarantees and promises are made. Therefore, the link in all of the publications about the subject matter is irrevocably tied to Mr. Hubbard's background. If they had someone from an ashram in India who had never been to school in his life and who felt that if you believe in whatever you want to believe in, you'll be cured, I would submit to you that's none of our business. But if you present an individual falsely to induce people to think that it's not belief, but it's science upon which you can rely and upon which guarantees can be made, then that is something, as the article or device case specifically says, you can deal with and you can correct. Also, Mr. Hoffman has just pointed out to me, in Dianetics, the Modern Science of Mental Health, which was purchased by someone within your city in the last now probably 72 hours, or perhaps further, perhaps 3 or 4 days ago, the opening page after the outline of the table of contents is the following statement: Dianetics is an exact science, and its application is on the order of, but simpler than, engineering.
Pardon me, what page is that on?
That's on page Roman numeral 9, which is the first page after the table of contents, which is the synopsis of the book. And I would suggest to you that in the book, which is an altogether additional issue, are many case studies, which I don't have the time to go into, but it's filled with case studies, years and years of case studies, which
I'm
is
curious,
important.
is that published by Vanity Press, by his own publishing company, or by a recognized publisher of books?
Most of the publications are by the Church of Scientology of California. This particular publication is by Bridge Publications, Inc., wholly owned by the Church of Scientology in Los Angeles, California. Regardless of who published it, it's disseminated and sold by the Church of Scientology of California in the city of Clearwater without the warning required by the article or device case.
We had testimony that Paulette Cooper was sued for her book because they alleged that it was false, misleading, etc., etc. Why can't that Bridge Corporation be sued also?
Well, Paulette Cooper was sued, and her book was taken to England by the church, and she was sued there. And both her publisher and she did not have the financial wherewithal to defend, so that to this day the book is not on the market. There were many lawsuits, as she testified, filed against her. She could not financially withstand them. In the book was not, the publisher did not continue in the publication of the book. If that book had in fact been published and people knew for the last 30 years, or in her case, in the last 12 years or 14 years, what this organization was about, or 12 years, the last 12 years what this organization was about, then I would suggest to you that there would be a lot more truth on the subject of Scientology than was suppressed by all of the lawsuits that prevented that publication from being published. To answer your question directly, it was sued by the Food and Drug Administration and Nathan Dodell. And the article or device case did originate from that publication, among others. And if you read the article or device case, which I believe for the record is in 355 F sup at page 371, if you read that case, you will see there's an appendix in the back of the case, and I believe, and the record will correct me if I'm wrong, that the first exhibit attached to the court's opinion is Dianetics, the Modern Science of Mental Health, and representations contained therein, which resulted in that warning, which was put in as an exhibit. But to stop you, Jim Calderbank, or the City of Clearwater, or Lavinda Van Schaik, or Paulette Cooper, or George Meister, or Jack Clark, or someone, Brown McKee, would have to bring a lawsuit, hire a lawyer, pay the lawyer to bring the lawsuit, to challenge the publication. And you've heard testimony about how much money the organization earns. You can draw your own inferences as to your ability to fight an organization without money, that kind of money. And also, as I suggested to you before, you can contact Nathan Dodell in the Food and Drug Administration and find out from him personally what it took to litigate that one case. With regard to the confidentiality of auditing information, which, in my professional judgment, is, at least from the point of view of basic human rights, one of the fundamental issues before this commission. It may not be as concrete as whether there are 10 or 15 or 25 people in a room, but in terms of what I suggest to be the insidiousness of this organization, and what I suggest to be the level of deception practiced by this organization, is one of the most fundamental issues to be considered by the Commission and scrutinized as to what the Commission can do to inform people who come to your city that their auditing information over the last whatever number of years that the evidence shows has been used for the purposes the evidence shows it has been used for, aside from the issues of the monetary issues of the money that's extracted based on representations of what auditing does. Aside from those issues, the information that is on deposit about human beings over in that organization and what that organization has done with that information is a very significant issue for this city to consider. I have seen, and the evidence is, I've put some of the documents in evidence to show you people the types of things that are in this information. And some of the documents pertain to, as you will see, some political figures, not in this city and not even in this state. But when an individual is subjected to e-meter auditing or a security check, and he's required to disclose every crime that he knows that he did, that his mother did, his father did, his brothers and sisters did, his uncle did, his best friend did, and at any point in time that information becomes useful for either investigative purposes by the organization or to directly use, they can go investigate the uncle, the brother, the sister, And if the information is given in specific enough detail by the individual who is being audited, all they have to do is go to those documents. So if they want to find out whether or not Paul Hatchett's cousin, God forbid, did something in 1972 at such and such a location, all they have to do is go to that auditing information and then go check that place at that time for whatever purpose they're looking into. The possession of that kind of information in an organization that uses it the way it uses it is a very substantial issue before this commission. There are highly respected members of the clergy, and there are churches throughout the United States, and there are psychiatrists throughout the United States, and there are doctors throughout the United States and there are lawyers throughout the United States who are given highly confidential information that is protected by very specific laws, where the lawyer, the doctor, the psychiatrist, the clergyman cannot disseminate that information without the permission of the individual. Well, this organization in this city, through laws I submit in this city, which can be enforced directly in this city to deal with this particular problem, which is, as you heard from the nature of the income that's being derived in this city, at least equal to every other organization around the United States, is of paramount concern in Clearwater, as opposed to Las Vegas, Nevada, or Boston, Massachusetts, or even New York City, or even perhaps Los Angeles, California. If in fact the evidence is true that the income in Clearwater is equal to every other place in the United States, including Los Angeles, the magnitude of the problem that you are deliberating upon becomes apparent. And the bulk of information possessed by the organization in this city about people around the world who are paying money in this city becomes apparent. And the use of that information in the way that it's used, as has been demonstrated in very small degree, I suggest, in the evidence that we've presented. And there's a lot of evidence, but based on the evidence that could have been presented, I suggest to you it's in a very small degree. Something has got to be done. Something has got to be done to protect a 19-year-old David Ray when he wants to leave the organization, to not be required to sign a statement saying he did all these things, to indeed lure him back into what could at least be described as indentured servitude. Or, if he wants to get out and he wants to come to Mayor LaShare or the Consumer Protection Officer in the city of Clearwater, he should be able to come and say, this is what the organization did to me, without fear that that organization or its attorneys are going to walk in before an official body and say, this is what David Ray is. The manipulation of people to prevent them from exposing the truth, whatever peccadillos are in their background, when the truth of what a particular organization is much more significant and substantial than some minor peccadillo, are two competing interests that this city has got to substantially weigh. Take, for instance, the testimony of Mr. Mayer. He was sent on 18 missions, if I remember the testimony correctly. He read from a telex. He described a situation in Manchester, England, where he went to a medical doctor and blackmailed him. That was basically what he said. If you go back over the record, I suggest that that's what it'll tell you. He went to Scotland, he went to Hawaii, and blackmailed some woman with threats of bestiality that he had from her auditing folder to get her to do a particular thing. In some cases, I think there was some evidence to raise the stats to get the income up. Well, you know, I would suggest to you common sense would indicate that if you are in charge of raising the stats in Hawaii, and someone of Mr. Mayer's ability, or whoever else runs this organization now, comes to you with that type of information, and it's an or else type thing, and you're already working 15 to 17 hours a day, maybe you would be induced to be a little more vigorous, to make a little more misrepresentations, or to do anything like convince him he's loony to get money into that organization. The suggestibility factors alone on that issue with an operative like Mr. Mayor or some of these other skilled people coming with that information to a person to get them to be a little more aggressive in their solicitation practices in the collection of income is a substantial issue before this commission, aside from all the other issues with regard to the use of the information for purposes of extortion, blackmail, manipulation, or whatever. In order to give you a flesh and blood example of what this type of thing does, we specifically correlated our evidence so that some people would be before you, such as Ernie Hartwell. Well, I heard Mr. Johnson say, well, what does Las Vegas, Nevada have to do with Clearwater, Florida? Well, I think it's quite apparent if they are making $500,000 a week during one period, or $1 million a week during another period, or $2.3 million at least once, here for auditing, based on slave labor, which is what we'll get into at a later point in time, then, and they're using it in the way that I suggested, if you can see a flesh and blood example of that, then you'll begin to realize that you're dealing with human beings and not just pieces of paper. As one exhibit, the one exhibit on this issue we put on the transparency showed. I mean, Ernie Hartwell is someone who was told that he was going to come to Clearwater, Florida. And he ended up in the desert giving them auditing information. And when he realized how significantly he had been duped, and he tried to fight back to the degree that Ernie Hartwell could fight back, you saw what happened. You heard from him what happened to him. You heard from Janie Peterson as an operative. And she was only, I suggest to you, in GOPR, Guardian's Office of Public Relations, which is probably the most neuter branch of the Guardian's Office. That's like Mr. Will here. I mean, those are the people who go out and show the public what nice guys we are. I mean, the Guardian's Office B1 in intelligence gathering divisions, but because of the high degree of compartmentalization, one generally has no idea what the other's got. They are just told to go do this and go do that with it. But you heard Janie Peterson testify how not only in the case of the Hartwells, she went out and used that information, or the organization, not Janie Peterson, the organization went out and used that information. Took it to the Las Vegas Review-Journal, issued a press release saying that he was a murderer, which is another whole issue, which we don't have the time for. Taped his conversations, edited the conversations, and then tried to use those against him. Took Tanya Burden's auditing files, which were, according to her affidavit, as you will see, for 2 years and some 3 or 4 months, taken here in Clearwater, Florida, while she coded and decoded telexes as a 15-year-old child for the GO and put on L. Ron Hubbard's pants, as her affidavit shows, and took off his pants and put his shirt on and walked around collecting his ashes, as her affidavit shows. And in the interim, when she wasn't doing that, she was coding and decoding telexes for a criminal conspiracy. Only they were double and triple coded, so she didn't even know what they were. And how their coding process works is another whole issue. And one of our exhibits is the correct use of code. But they took Tanya Burden's auditing information and telexed it from Clearwater, Florida, and sent it out to the GO in Las Vegas, and the GO, as Ms. Peterson testified, used it out there, and also Lavinda Van Schaik. Well, with regard to the Hartwells and Van Schaik, those people appeared before you. They told you what they did. Then you saw them, and you saw the GO operative and what the GO operative did with it. That's a real example, totally correlated, of how the information is used. But I would suggest to you that that example should not just be, as an investigative body, one of your responsibilities, together with all of the other information and evidence before you, would be to infer from that how widespread it is based on the policies, one of which was introduced into evidence by Mary Sue Hubbard, to use the information and I think you may recall the policy says to use all ethics personal processing files. So that is just one example. And a very significant point. Very significant. Mr. McKee testified that up in Connecticut, per policy, he sent the files to Flag. And he didn't know what they were doing with them. And if he'd known, he wouldn't have spent 24 years in the organization or paid whatever amount. I don't believe he testified how much he paid. I happen to know, but whatever he did pay, assuming he did, or would just draw the inference from what other people paid. So some 19-year-old child from Clearwater whose auditing files, if he began in Los Angeles like David Ray, who didn't get that much auditing, fortunately, but I would suggest to you that perhaps Casey Kelly coming from Oregon or Lavinda Van Schaik coming from Las Vegas to Flag, and all of those auditing files being sent from Las Vegas to Flag when she came here, and now in the possession of this organization here, and used in the way they were used against Van Schaik, all of those issues demonstrate what's being done with that auditing information.
And then, please, did Mr. Gay say he stopped sending those from Connecticut?
I believe he says now that he has stopped sending them. For a long period of time he testified that he did, and he now doesn't. He is now, as he's testified, disassociated from the organization, so he wouldn't be sending anything to them now. But I believe he specifically testified for many years that he did, but he stopped now. And yeah, I think he did say that he'd burn them now before he would send them, now that he knows what he knows, which is, of course, the whole fundamental issue of deception, which is the fundamental issue underlying the two ordinances that we have proposed dealing with consumer fraud and charitable solicitation of funds. And on that point, as our very minimal case study shows, or preliminary case study shows, the Supreme Court has constantly said over and over again, and they just said in connection with this Minnesota case involving the Unification Church, in this case in New Mexico. And the cases are set forth in our preliminary report, particularly the Schomburg case. The Supreme Court has said over and over again, when you're dealing with charitable solicitation of funds in purported religious organizations on their face, you can't, if the organization makes 100 misrepresentations, or makes 100 representations of which 10 are false and 90 are accurate, you can't completely shut down all of their solicitation. It's too broad. You can't simply vest in a public official the right to not grant the permit to solicit. Cantwell v. Connecticut, in every case since, has repeatedly stated you deal with the fraud. You don't ban the entire solicitation practice, or their right to solicit, until after an adjudication, and you deal with the fraud. If the fraud permeates the entire solicitation practice after an adjudication, well, then that's what you'd be dealing with. So we have drafted our ordinances to comply with the Supreme Court cases to deal with the fraud, not to simply vest in a public official the right to deny a permit, which is what every other Supreme Court case, when they have struck down ordinances of that type, have done. And the League of Mercy case in Jacksonville, when they enacted an ordinance, I submit to you, has been upheld by the Florida courts. And yet, in our professional judgment, that particular ordinance is also unconstitutional. But an ordinance, as Cantwell v. Connecticut says, and Schomburg says, every case virtually says, deal with the fraud. Don't ban completely the practice by simply allowing a public official to say, no, you can't do anything. Deal with what is fraudulent. With regard to some of the issues, the legal issues that deal with the confidentiality of auditing information, in terms of criminal activity, it permeates extortion, blackmail. In terms of some civil responsibilities, it permeates issues concerning invasion of privacy, breach of fiduciary duty, breach of contract, fraud, misrepresentation, all of those issues. Most of those things can be dealt with in a consumer protection statute. If there's a consumer protection ordinance that specifically says you can't do it, you can't tell someone that it's going to be held in confidence and then not hold it in confidence. And then if the person does it and you have a lawsuit against them, in an adjudication punishable by a $50,000, $100,000, $150,000 fine, whatever is warranted based on the degree of harm or the degree of wrong, then every time it's done, that penalty is imposed. And that's a very simple thing to regulate. Then arises the issue of some type of injunction. If they do it in any pattern per policy, then you can prevent it possibly altogether if there's strong enough evidence. Or you can post perhaps a placard right behind the registration desk, just like a warning on a cigarette package, just like the warning in the article or device case, that the organization is a practice of doing it, and every time they do it, fine is levied. Or everyone who walks in that door sees in large capital letters, this organization from such and such to such and such has done the following with your auditing information, or perhaps in a more legalistic manner. And as our ordinance suggests, all of this would not be simply vested in a public official to go do it, which would probably be unconstitutional, although in some instances it may not be, depending on various standards that could be used, but it could easily follow an adjudication. And if the issue was compelling enough to the community, as I suggest this issue is compelling enough, perhaps it could be treated expeditiously in the legal process so that some corrective measures and remedial processes can be invoked. I would suggest to you that if that type of deception, along with the other types of deception we've talked about, is one of the ways they make money, it may have some impact. With regard to the evidence on this issue, I've already gone over a little bit of it. There's a lot of it in the exhibits. There's been a number of witnesses, all of whom have testified that if they'd known, they wouldn't have given the information or that they wouldn't have paid the money. There's substantial evidence for, and we intended it to be so on that issue for that reason. But even Mr. DeWolf testified, if you wanted to believe him, that as far back as 1954, his father was bugging the auditing rooms. In terms of pattern, that pattern, I would suggest to you, has been taking place from 1954 right up to at least Jane Peterson's testimony. And maybe, right up to today, if David Ray's information came from where at least I would suggest it came from.
Can we have Mr. Ray back to give sworn testimony as to the information he put in the auditing file, since he is not aware? Can we take deposition
I think that
on the West Coast to find out if Mr. Ray, in fact, indeed, gave this information? That would show the pattern, if one exists, up to the present day today, May 1982. I'd like to request the Commission take the steps to have Mr. Ray's deposition concerning this issue.
I would suggest to you that that level of persistency is what will cure the problem.
Mr. Flynn, you mentioned about the auditing and the if the evidence and transcript and record shows that indeed there's a pattern or need for some kind of consumer protection. How do we, after hearing the testimony, how can we ascertain whether or not the auditing or confidentiality is being broken on a regular day-to-day basis?
I would suggest to you that the more openness that is injected into this entire operation, the more people are made aware that there is someone to go to, the more they're made aware of the fact that things are not as clandestine and secret as they're led to believe, the more that the truth can penetrate on whatever way it can penetrate, Maybe it would start with a Paulette Cooper. Then maybe it would go to a Lavinda Van Schaik or a Nan McLean, and then to Janie Peterson's, who in my opinion was one of the most courageous witnesses for reasons known to me to appear before you.
Janie Peterson. Commissioners, you have just a limited amount of time to speak, sir, and I would rather prefer that we allow you the time, and if we still have questions of you, we can ask it of you at your concluding remarks when the time is ours.
Thank you, Mayor. But I would suggest to you that more Scott Mayers, as he suggested to you, and on that point, Scott Mayer, when he testified, dragged out some, Scott Mayer is a very thinking person, I would suggest, and he dragged out some outlines of things that he thought you should do, and Mr. Burfield asked him whether he had discussed it with us in advance. Well, I tell you, and I would go under oath, that I had no discussion with Mr. Mayer in advance about his particular outlines, but I was happy to see that he had thought through some of those things and presented them to you. But there may be, if more truth is injected into this situation, which for at least 7 years in this city has basically been a matter of media attention, if more truth was injected by whatever manner, in whatever way, into the situation, there'd be more Scott Mayers and more Janie Petersons and Tanya Burdens and Lavinda Van Schaiks who have the courage to come forward. So in response to Mr. Calderbanks, you may get kids more willing to walk across the street in a little less state of fear. Or maybe if there was a little less state of fear, they wouldn't even be there. And if there was a notice behind the regging desk or the cramming room that those legal options existed, a notice posted by this city, maybe they'd begin at least to look at it and think about it, and the regger or the crammer may say that's just a legal problem. Forget about it, it's got nothing to do with us. Well, he may think a little more, just a little, and that one little thought at some point may induce him to come forward. Now, we're on our third area. There's, I think, 12. We'll have to move quickly. With regard to deception of the overall nature, purposes, organizational structure, what the organization is, what is Scientology to someone who is first presented with it? There are just unending issues. There are issues concerning primarily, I would suggest, the fair game doctrine. Well, they say they canceled it. You saw the cancellation. This policy letter, what we're not going to do anymore is we're not going to put on ethics orders that the fair game policy exists. That's what it says. We're not going to put it on ethics orders. In other words, we're not going to put it in writing. It causes bad public relations. This policy does not cancel any treatment of an SP. That's what it says. And I suggest the Church of Scientology come in here right now with their version of the cancellation. And I suggest to you that some of the exhibits we put in, such as Exhibit 4, was a fair game declaration with the policy date in it. And the policy date is 1965, and the second one, there's a long fair game policy and a short one. They both integrate with one another. They're Exhibits 1 and 2, as you'll see. The cancellation is in 1968, 2 years after those two were adopted. The fair game declare that we put into evidence is dated 8 June 1979. Referring to the policy in 1965. I suggest to you that any common sense interpretation would tell you that it hasn't been canceled. Then you get into the issue of conduct. And those are the pieces of paper, their own pieces of paper. Then you get into the question of conduct and the inferences to be drawn from conduct. The inferences to be drawn from Operation Snow White to penetrate every national agency across this country, which is one of the exhibits. And that took place in the 1970s. The cancellation was in 1968. Or Operation Normandy, or Operation Taco Less against your former mayor, or Operation Speedy Gonzales, or Keeler 1 or Keeler 2. Those took place in the 75, 76, 77 era. Merrill Veneer, pursuant to one of those operations, penetrated your former mayor's law firm in the 70s. Or what they did to Tanya Burden or Lavenda Van Schaik through the use of auditing information. I mean, the inferences to be drawn from what was done to them as late as 1980 in terms of lying, cheating, or destroying, there are very clear-cut legal inferences, as any trier of fact could find, from just the conduct alone. And the conduct is substantial. Right up to Mr. Johnson appearing in this room here today with David Ray's information, if you decided to draw that inference. Most witnesses, I believe, testified that they wouldn't have joined the organization if they knew the criminal operations were taking place. So whether fair game is canceled or not canceled, there's no question that these criminal operations, 11 people have been convicted and 10 of whom are in jail. And the 11th, I'm sure, it'll be quite immediate where she will go to jail. Every witness, I believe, testified, or almost every witness, that they would not have joined the organization, paid money, provided labor, did whatever they did, moved beds for 16 to 18 hours a day, took invoices like Casey Kelly did. Whatever services were provided or monies paid, they wouldn't have done it if they'd known that this organization was breaking into or into places pursuant to their operations on how to break in, or infiltrating the Clearwater Sun, or conducting all these hundreds of other operations that have been put before you. They wouldn't have done that if they known the organization had a policy to do such things. And I believe specifically McKee of 24 years gave some evidence on, at least inferentially on that issue. Kelly of 3 years and Ray of 6 months. That covers a long time span. If they knew that those criminal operations were taking place, they wouldn't have joined that organization. That in itself is an organizational deception. What the GO does, what it has done, what it continues to do, the written policies it's got to do it, is all organizational deception. With regard to just some of the peripheral links to Clearwater, you've got all of the operations in Clearwater, which we haven't even discussed. Then you've got Project Owl, which came from Clearwater, originated by Mitchell Herman. You've got Burden's auditing files going out from Clearwater to Las Vegas, the Hartwell enticement to come to Clearwater. All of those are types of deception, which had they known about the nature of the organization, its goals, purposes, etc., they wouldn't have pursued.